Welcome to the Seeing Red podcast with Andi Turner and Garrett Fulce, checking up on Texas policies and politics with some federal issues thrown in, like the assault weapons ban, interest rate hikes, you get it, but it's mostly Texas, since we can't ignore the big stuff either. And now, here are your hosts, Andi Turner and Garrett Fulce.
Hey everybody, welcome back to the third episode of Seeing Red with Garrett Fulce and Andi Turner. We are delighted you have joined us. Don't forget, former teacher here, so you always have homework. If you have not liked, subscribed, followed, whatever, so you don't miss a single episode, we would very much appreciate that. Also, Garrett, one thing we've forgotten to do is thank our producer, Zipmeister, for all the hard work he's put in to help this show sound as professional as it does. I know you work with him, but he's been great to work with. So I just want to give him a special shout out. So, okay. So what's new?
Well, I did want to make sure we said at the top that we have episodes every Wednesday. We're dropping these into your inbox, into your streams, onto the podcast platforms where you are listening. And also on the website, seeingredpodcast.com. We are everywhere podcasts are found. We have the podcast streaming on our website. You can find it easy, seeingredpodcast.com, via our socials, which all of our social handles are at the Seeing Red Pod. We're really active on Twitter and Facebook. We'd love to hear from you on our social media platforms. We'd love it if you gave us an email at host@seeingredpodcast.com. That's the best way to get a hold of us quickly, and we'd love, our DMs are open on Twitter, so if you want to send us some love or send us some hate or send us some basic information that we get wrong, please feel free to do it. We'd love to hear from you.
You will get a response from us. I mean, there's no question. So don't worry about it going into some general mailbox. Nobody answers. If you send me an email, you're getting an answer. I can't guarantee you're always going to like the answer, but don't hesitate. You can contact us at seeingredpodcast.com, or you can email us at hosts@seeingredpodcast.com. And all of our social media, because of the limitation of characters, is the Seeing Red Pod.
We are everywhere podcasts are found.
Yes, we are.
It's been a lot of fun getting those started, and it's been really fun not having to worry about doing all the social media stuff. I'm from a background where that's usually part of my job description. But for this, the Zipmeister has been fantastic at helping and pitching in, and Zip has done a great job of helping with that. Andi, I don't have a whole lot of personal stuff. I did go to my county Republican executive committee meeting this week. I am not a precinct chair. My precinct chair is extraordinarily active and very, very good at doing that role. She's probably one of the top 3, if not the top precinct chairs in the county I live in. But it's not like a lot of our seats, which, Andi, you may know this, but there are a ton of vacant precinct chairs across the state where that's a vital role that the party needs filled, and there's not a lot of efforts by county parties to get those filled. There's some lip service towards it. There are some people working on it, but it's not a real priority to get folks in those positions to really help grow the party. And it's really something I think a lot more people need to, if they are listening to a podcast or they're watching the news all the time, or they just want to get involved and they don't know how, the first thing you should do is check and see if your precinct chair is vacant or not, and then step up and do it.
I have not even heard from mine. But, it's funny, not every state does that. I was working on a congressional campaign. Campaign manager called me and said, all right, so who are your precinct chairs? And I'm like, yeah, we don't do that here. This is in a different state. And he was like, what do you mean you don't do that? I'm like, the Central Committee divvies the work up across each county.
Well, I think it's a good opportunity, because I don't think we've talked about it in an actual episode. Tell people about what your background is, because we're not journalists, but we're also not just people off the street. I think we have a combined over 30 years of experience in Republican politics. We are Republican operatives.
Yeah. And if I haven't done it, Garrett's done it. Garrett hasn't done it. I've done it. So like I've been a chief of staff to state senators, state house members, and I've been press secretary. I've been comms director. I've been legislative director. I've been registered lobbyist in 2 states. I've been chairman of the county party. And then I get to Texas and, I want to get involved. And that's how I actually met you, was because I had contacted the campaign you were working on and they needed somebody to make phone calls. And this is in the middle of COVID. Like, we moved here 6 months ahead of COVID. Thank God, because believe me, it is a much better thing to be in Texas during the pandemic than it was to be in Maryland.
Well, what I think of when I think of Maryland, unlike most people in Texas, is Lieutenant Governor Dan Patrick. Lieutenant Governor Patrick's from Maryland, went to the University of Maryland, Baltimore County, and I think he's going to be a big player in what you talk about today. Is that right, Andi?
Yeah, he is front and center. So we promised you last week that this would be the week that we talked about the rules. And it's important that y'all understand the rules because this is a legislative trial, not a criminal justice civil suit type of trial. And there is a difference.
Okay, so impeachment came about because the U.S. Founding Fathers wanted to have a mechanism to remove officials who typically can only be removed by a vote of the people via an election if there was something that arose where their reputation or integrity would be seriously damaged, or something like where they have committed a high crime or a misdemeanor. So that's going to be treason, bribery, any real felony, and they sought to figure out the mechanism that would work best to do it. And they looked at the judiciary, and they found that a civil or criminal trial, and that the person couldn't get a fair trial, and seeing that there was no way to guarantee a fair trial, they sought to strip any of the civil or criminal penalties from the actual impeachment process. And there's a lot of argument about it in the Constitutional Convention. There's a compromise, and then the Federalists, and Alexander Hamilton wrote the Federalist Papers, number 66, in which he justifies the impeachment process, which Texas mimics very closely, by basically saying the power is vested in the House, because the House is the closest body to the people. The power of impeachment, which is the prosecutorial power and the indicting power, comes from the House, and the right to try and to weigh the evidence is found in the Senate.
Okay, so what you've been saying is that the House is considered the chamber that is closest to the people. They represent more of the grassroots than, say, the upper chamber. And the founding fathers of this country wanted to make it difficult and made this framework so that it isn't easy. And Texas has used the framework to develop these rules to make it difficult to oust someone. Now, on to the rules. So the trial will start at 9 a.m. on September 5th. You'll be able to watch it online, or you can go in person. But they'll cycle people through. If you go in person, expect that there's going to be a lot of people who are going to be wanting to sit there and watch, and they're going to cycle through so that everybody gets some time watching what's going on. And I said this before, this is not a criminal or a civil trial. He will not go to jail if he's convicted or the article or articles of impeachment have been sustained. In other words, they have been found to be true. He can, however, and will likely face criminal charges in a court of law on many of these things. And I'm reading a few more now, so we don't know at the results of that at this point. We don't even know who the witnesses are. Lieutenant Governor Dan Patrick is also the president of the Senate. That's the way it's done in Texas. He will serve as the presiding officer. The sergeant-at-arms will be the bailiff, and the prosecution in this case will be a group called the House Board of Managers. 11 of the 12 are lawyers, and one is not.
I think the one who's not is Charlie Guerin, right?
Right.
I think he's on there by virtue of him being on the House Investigation Committee.
Well, Representative Garrett does not have a law degree, but he has served as a representative for more than 20 years, so he has some seniority here. There are 7 Republicans and 5 Democrats on the board. Representative Andrew Murr, Republican from Junction, Texas, and Representative Ann Johnson, Democrat from Houston, are serving as chair and vice chair, respectively. So we're going to break down who all these players are for you next week in terms of personalities and what we think some of them may or may not do. It'll take too long to do that today and do the other things we want to do. To keep you all from getting too confused about all this or bored, God forbid, I'll sum up most of the rules by saying it will look like most of the trials you're familiar with. There is one major exception. If there is a motion to dismiss a single article or several articles of impeachment, he must defer to a vote on that motion of the jury, and that is the senators present and allowed to vote. During the trial, a motion to dismiss an article of impeachment requires a simple majority of senators present and voting. In the event of a tie, we can find no reference in the 28 pages of rules as to whether or not the presiding officer can break the tie, as he would do if he were acting as the president of the Senate during regular session or special session. Therefore, if there is a tie, the motion will fail because it is not a majority. The defense will be represented by the Attorney General Paxton or his attorney. More than likely, he's going to be smart and let his attorney speak for him. But, again, like I said, anything can happen and usually does. The presiding officer is Dan Patrick or his designee, and the jury is composed of most of the duly elected senators except for one. Rule 31 of the impeachment trial states that any member of the court who is the spouse of a party to the impeachment is considered to have a conflict of interest and has no voting privileges and cannot be present for deliberations and voting. They must, however, attend the trial. I call this the Angela Paxton rule because I can't think of anybody else it applies to. As Ken Paxton's wife, she is deemed to have a conflict of interest, and as a sitting senator who would otherwise be a quote-unquote juror, Senator Paxton has no voting privileges. She is constitutionally mandated to attend, but she may not take part in any voting that goes on, and her presence will be counted towards determining a majority and what 2/3 is. And we're going to get into 2/3 in a minute. This means that it will take 16 yay votes to dismiss a charge, in other words, an article.
Yeah, that's really interesting. There's been a lot of flack in the press about this and about the fact that Angela Paxton will be counted toward the overall vote total in a way where she doesn't actually have to vote, but also the kind of like the carrot to the prosecutors is it's going to make it a lot harder for the pro-Paxton factions in the Senate to get a charge dismissed. Because I think the one way to look at this is before any evidence is laid out, it takes a simple majority to get rid of an article of impeachment. After the evidence has been laid out, it only takes 11 votes to get rid of an article of impeachment by not voting to sustain. So the threshold lowers after the investigation's been completed. The value to that being just we get to see the investigation and make our own decisions towards whether or not Paxton should be removed, and then would be able to hold office holders accountable for their vote to impeach or their vote to whatever. The people need to have the information that the senators should be getting, and it should be a trial that actually happens because the House did vote to impeach.
Right. There are strict admonitions against discussion amongst the jurors, and also even the witnesses. They can't talk to each other. They can't watch the hearing. They can't watch the news. I mean, they're very serious about how the evidence is going to be presented, and deliberation comes after all evidence has been presented. And of course, there's a gag order on anyone who has anything to do with the impeachment trial. There's been a great deal of speculation about whether or not the AG has violated that order given. What I find interesting, and yeah, some of it's just interesting, and some of it's just things that are, like Arsenio Hall said, Things that make you go, Pretrial motions are handled by the judge unless, like, he literally can take a pretrial motion and say, nope, we're going to have this voted on.
The thing to look out for to kind of get an idea of how this is going to go are going to be how those senators vote for the motions to dismiss on the first day. Because first off, the motions could be dismissed. But if you're looking at the margins to kind of indicate which way it's going to go, you're going to have a pretty good idea of the math based off of how those motions go. So if you want to, that's something I think is important to note as well.
So moving on the rules, and Garrett, we're going to get more into that next episode. By the way, if you not listened to last week's episode, please go listen to last week's episode. When the trial is over, each individual article of impeachment will be voted on by the jury. To sustain an article of impeachment, in other words, to say, yes, we think A.G. Paxton is guilty of this article of impeachment, there must be 2/3 of the jury voting to sustain the article of impeachment. If any of the articles are sustained, Attorney General Paxton will be removed from office for the remainder of his term, and then there will be a vote by the jury as to whether or not A.G. Paxton should be barred from ever running for state office again. If any of them are found by a 2/3 majority to be sustained, then it will be reported to the Secretary of State and A.G. Paxton will be permanently removed. Now, I feel like that's a good stopping point. Those are the rules. If you don't understand the rules, you may be looking, if you're watching this on your computer or on your TV or whatever, you may think, well, no, wait a minute, that's not right. That's not how they do it in court, because this is not a judicial court. This is a legislative court, and things are different, and that's really important to know. So moving on from this, because the Attorney General is not the only thing in the news.
Well, actually, Ken Paxton is still in the news, and it's not just for the impeachment trial. There is a case coming out this last week that is talking about there's a news article that came out that's talking about Ken Paxton's office arguing that the state is not liable to pay for prison guard's miscarriage that was caused by the malfeasance of her supervisors. She was told by her supervisors that she couldn't leave her post even though she had started to have contractions at 7 months. And she took them hours to get somebody to replace her. Some text indicating that they thought she was faking it and all this other stuff. And now Ken Paxton is arguing, or his office is arguing, before he was suspended, that the fetus is not considered viable under the 14th Amendment, and the state is not liable to pay for any injuries, even though it was directly caused by the policies of the state and everything else.
Wait a minute. Hold the phone. So you're telling me that this woman was having difficulties with her pregnancy, whether she was in labor or there was a miscarriage of something, who knows what was going on. And her bosses were like, yeah, you can't leave. For whatever reason, you can't leave. This is our policy.
So yeah, let me just read you some of this reporting. There's a federal lawsuit, and I'm going to butcher this pronunciation, so I apologize to this woman. Salia Issa had just begun her shift as an Abilene prison officer when she felt an intense pain of what she believed was a contraction. She was 7 months pregnant, and she quickly alerted her supervisors and told them that she needed to go to the hospital. No one came for hours, and because she knew that prison policy wouldn't allow her to leave her post until someone could replace her. She kept calling. The supervisor repeatedly refused her, telling her she was lying repeatedly. You just want to go home, the supervisor allegedly told her. 2.5 hours after the pain started, she was allowed to leave as quickly as she could. By the time she got to the emergency room, they quickly admitted her, and they were unable to find the fetal heartbeat. The baby was delivered stillborn.
That's awful. I mean, you've got a 7-month pregnant woman, and you just want to go home early? I mean,
Yeah.
She's
who
pregnant.
Says that? Who says that?
First of all, I have no idea. And look, I understand that these guys that work at these prisons and these jails, they got a tough job, right? So they got to be, well, pardon me, but hard asses. But she's 7 months pregnant, guys.
But beyond that, the Attorney General's office wrote in a March footnote, this is from March, which referring to like a constitutional right to life, said that just because several statutes define an individual to include an unborn child does not mean that the 14th Amendment does the same. But this is after Ken Paxton staked his reputation on defending the unborn all the way to the Supreme Court. And he's arguing that it's not clear that the fetus, quote unquote, had rights as a person. So Ken Paxton is all for life until it means paying for a lawsuit. And he's all for challenging a lawsuit if it's going to, because on his case for this trial, he's all for challenging a lawsuit and settling out when it means he doesn't have to testify. But God forbid he do what's necessary when the state has screwed up in such a way.
First of all, before we go any further, because I have all the thoughts on this, credit the journalist who wrote the article and where you found it.
Yeah, so this is by Jolie McAuliffe with the Texas Tribune.
So I always like to give credit where credit is due. So thank you, Jolie, for that report.
And this is Salia Issa, her husband, their unborn child versus the Texas Department of Criminal Justice. And then individually named are her supervisors in their individual capacity, it looks like.
I can't even wrap my head around the fact that a 7-month pregnant woman came to her boss and said, I'm in some pain, I'm worried. And they were like, well, I mean, I don't care. Let's say she's a total slack off. Let's just assume for a minute that this pregnant woman was like not a good employee. I don't care. This woman is 7 months pregnant. Now, if you want to let her go and she's a slack off and she's not doing her job, there are rules for that. But she's working for you and she's in physical distress and you denied her care. And as a result, she suffered a serious loss. And I'm sorry, A.G. Paxton, who, fought to have no abortions in Texas under any circumstances, is now saying, oh, well, it's not viable. Well, first of all, with machines, a baby is viable at about 6 months.
Actually, it's about 5. It's at 22 weeks now.
So she's 7 months pregnant. So don't tell me. I mean, we have thousands of cases of 7-month-old preemies being born and doing just fine.
Oh, I may have misspoke on the viability. They're saying that it's just because the fetus wasn't born, quote unquote, that it doesn't have rights. Now,
really?
The dichotomy, or the thing I really want to draw here, is that not only in this case that has to do with the right to life, these are a case being brought of hostile work environment and gender harassment, hostile work environment, denial of a reasonable accommodation, disparate impact toward the disability, denial of a reasonable accommodation, and then also cites the right to life, bodily integrity, supervisory liability, right to be a parent, and all these other things. What the dichotomy I really want to draw, though, is this is a case that involves supervisor misconduct, and it wasn't settled for an undisclosed or disclosed amount of money, right? It's gone, and he's fought it, and he's used arguments that were specious at best, but beyond that, or his staff did, and he allowed it. But beyond that, in his own case, he said, oh, no, it's just going to cost too much. We just got to settle it. So a case like this, where he's not defending the life, he's not defending the preborn, he's not being this big old advocate for the conservative movement that he claims to be.
Right. His job is to defend the state, right? That is his job, is to defend the state. And I understand that. Okay. But if I am the AG And this is being reported in the Tribune and God knows where else. It's bad, bad press. I want this to go away. If I'm the AG, I want this to go away quickly.
And he could score. He could have scored. He could have scored political points. He could have settled and said, "Here's the state."
Oh, he's
values.
not settling?
He's not settling. He could, he's not settling. He could have had a political win for the pro-life movement if he said, we do see that this child was a child that you lost, and it was because our employees were negligent in how they treated you and your condition. Here's a settlement, and here's how we treat cases where our preborn citizens are harmed, right? I mean, in this case, it's ridiculous.
Let me just wrap my head around this. You can't have, in the case of rape or incest in the state of Texas, you cannot have an abortion. But if your supervisor who works for the state interferes or, frankly, doesn't interfere while you are in distress during your pregnancy, oh dear God, I don't even know what you just dropped a bomb on me.
She was 7 months pregnant. Simple back of the envelope math puts her at 31 to 32 weeks. Even in Western Europe and a lot of liberal jurisdictions, that is past the point of any sort of abortion, right? And we're talking about a child. We're talking about one that could have survived if she had been able to get, the doctors say if she had been able to get to the hospital in time or more quickly, she would have been able to either keep the pregnancy going or would have been able to deliver early.
Oh,
it's not just a case of something had gone wrong and the child was with the child. The child was okay. Once again, it was at 7 months. There had been no deformities found. There had been nothing found.
I don't even know what to say. I can't believe there's no labor law in Texas that covers. I mean,
I can't believe that they're fighting the labor laws that do exist in Texas for this kind of situation. And this is Ken Paxton, defender of the preborn, the defender of life. Who will go to any right to life rally and talk about all the work he's done. And then in the case when it actually matters, in a case when it matters even more because the state accidentally caused the death.
This woman. When did that event happen in that prison that she worked at?
November of 2021. They sued about a year later.
So November of 2022. So we're still relatively early in this. I'm praying that this woman gets what's owed to her.
I think that the case may resolve itself in the plaintiff's favor at some point, especially now that it's getting some the kind of scrutiny that I'm sure it's going to receive more of. That said, I think that the major point here is that Attorney General Paxton is banking right now in his impeachment trial on the support and fervor of a crowd of folks on the hard right. It's a bad look to them to have to now defend the guy who doesn't think in legal proceedings that a 7-month-old fetus is a child. I mean, I don't know how you square that circle. And I want to make sure in this case, I do give the latitude to the Attorney General's office to make sure that the state and us taxpayers aren't overpaying for negligence by employees of the state. I do understand that. But I think the big value judgment here is the argumentation used. I don't really understand how you can justify that when given all your campaigning and whatever else you've done as an argument that's okay, that flies in your department.
Thank you, everybody. We are so glad that you joined us this week. Very interesting things in the news. Garrett just dropped that last bomb on me, and I'm still like, what the heck? But we appreciate you tuning in every week, and we will see you next week, and we're going to have a big discussion about the drama in Austin, so there is a cast of characters.
You call it a drama, I call it a farce. This is going to be a comedy. A lot of clowns in the next episode.
But anyway, we will be back next week with that episode. We look forward to hearing from you, whether it's on Facebook or Twitter or on our page, seeingredpodcast.com. And, of course, email at hosts@seeingredpodcast.com. Anyway, we will see you next week, and thank you so much for joining us this week. Bye, guys.
You've been listening to the Seeing Red podcast. It's always Texas politics and beyond. We present the facts and opinions. The Seeing Red podcast with your host, Andi Turner and Garrett Fulce. Thank you, and tune in next week. And please do us a favor. Hit the subscribe button so you don't miss a single episode.